Well, I just took a big L. Hello, my friend. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. Just a little bit ago, Judge Lyman from the Southern District of New York filed a ruling in response to my motion to seal or redact my sensitive personal information, like my physical address, phone number, and email. Very sensible, I thought. This, however, is what the judge says, and I will share with you my reaction to that after we read it. He says, quote, non-party Mario Armando Lavandeira Jr., hey mom, also known publicly as Perez Hilton, moves for an order to seal or redact any personally identifying information from the public docket. Lavandeira supports the motion with a declaration noting that he is regularly the target of harassment and is concerned that his address, phone number, or email address could be disclosed. Docket number 471. The court already has taken measures to protect the privacy of third parties in this matter. I'm going to save it till after we finish reading this. On March 13th, 2025, the court entered a protective order. See docket number 125. The order was entered pursuant to the court's power to take measures to protect against the unnecessary disclosure of information damaging to reputation and privacy. See docket number 124. The protective order provides that any person producing material in discovery may designate as either confidential or attorney's eyes only non-public materials, the public disclosure of which will cause harm to the personal interest of the producing party and or a third party to whom a duty of confidentiality is owed. Docket number 125. Information that may be designated as confidential specifically includes, but is not limited to, telephone numbers, email addresses, or physical addresses. The order imposes duties on persons receiving such confidential material. If information is designated confidential, it may only be disclosed to counsel, the court, and others involved with the litigation, not the public. If a party is asked to produce information in discovery that is subject to contractual or other obligations of confidentiality to a third party, the party must inform the third party, and the third party must seek a protective order or other relief from this court. The federal rules of civil procedure and the court's individual practices in civil cases also provide further protections. Under Federal Rule of Civil Procedure 5.2, a party may not publicly file a document containing a person's social security number, date of birth, or full financial account number. The court's individual practices in civil cases contain specific procedures for the filing in court of a document that contains information marked confidential by another party. Individual practices in civil cases, Chambers of Lewis J. Lyman, Attachment A. Thanks, Judge. The individual practices specifically provide that a party filing a document containing the confidential information of another party is to file it under seal with a request that the court not make the information public for at least 1 week to permit the producing party an opportunity to seek continued sealing. The parties have been careful to file confidential information under seal. In general, the protection of personal identifying information of non-parties is a higher value that merits sealing. The court has granted several motions to seal personally identifiable information in this case. See dockets number 292, 434, and 485. Lavandeira seeks to ensure that his personal information is not disclosed publicly on the court's docket. However, he has not identified a specific need for the court to take an action that it has not already taken. A non-party seeking to intervene in a case must show an interest at stake. Lavandeira does not identify any of his personal information that is currently on the public docket, so there is nothing for this court to seal or redact at this time. As to the future, the privacy protections discussed above are already in place. These protections allow Lavandeira to ensure that any contact information he produces in discovery remains confidential. Lavandeira states that he has reached out to plaintiff's counsel to ensure that his personal information is not publicly disclosed, and there is no indication that plaintiff's counsel plans to disregard this request. Docket number 471. Given the procedures already in place for maintaining the confidentiality of personally identifiable information, there is nothing for the court to address at this time. Accordingly, the motion must be denied. The motion to seal or redact is denied. The clerk of court is respectfully directed to close dockets number 470 and 478. So ordered, Louis J. Lyman. Okay. My first thought was, not surprising. Judge Lyman is not only besties with Bully Lively's lawyers, but by now it seems pretty apparent that he is also besties with her as well. Now, if I was one of the defendants, I probably wouldn't say everything that I have to say, but fudge, I'm not. I don't care. This judge is corrupt. This judge is disgusting. This judge needs to be removed from this case. This judge had the audacity to, in his response, in this just filed order, cite an instance where he granted a motion to redact. He says, the court has granted several motions to seal personally identifiable information in this case. See dockets number 294, 434, and 485. This judge is either dumb or thinks that we are dumb. Docket number 485, which he referenced, is to redact the personal home address of Cynthia Barnes Slater. Only after disgusting Delulu's lawyers doxed her home address. And at the moment I am making this video, if you go to docket number 440, the original exhibit, affidavit of due diligence, in the court's docket still lists this woman's home address, exposing her to potential harm. Or what is believed to be her home address. I hope it's not her home address. That's where service of the subpoena against Cynthia Barnes Slater was attempted. And that address in docket number 440 is not redacted yet. Additionally, Judge Lyman knows that I am representing myself pro se, without an attorney. What harm would have been caused by this extra layer of protection? No harm, none whatsoever, but it sets a chilling precedent for all of the non-parties sucked into this mess by Blackface Blake. Just last week alone, more than 5 non-parties, content creator, journalist, filed motions to quash, most of whom were representing themselves. What Judge Lyman said in this ruling today in response to me is that he has complete disregard for my safety and well-being and that of all the other folks that have been harassed through disgusting discovery, and that the onus is on us to know, oh, you can designate this as attorney's eyes only or confidential. What if I did not know that prior to submitting discovery material if I was forced to? What if some of these other creator journalists did not know that either? He is aware of who he has been dealing with recently, and he is treating them like poo. That must be because that's what he eats a lot of. I hope the judge sees this. I hope he knows what a piece of he is. The audacity to cite Cynthia Barnes Slater when her last known home address is still unredacted on docket number 440 in your courtroom. And earlier today, Judge Lyman also denied the request for sanctions that every single one of the creator journalists last week who filed motions to quash asked for. Because, of course he would. This is Judge Lyman we're talking about. Justin Baldoni is screwed, sadly. We know. We've already seen he's not getting, and he will continue to not get, a fair shake, a fair trial, fair proceedings from this judge. In my opinion, my protected opinion, my opinion that I can't be incarcerated for, to say this judge sucks. This judge is awful. This judge makes me want to vomit. This judge is a disgrace to the legal profession. That's my opinion. What's yours? Let's discuss it all in the comments section.